I now call the third case on this morning's docket. That is case number 114827, Board of County Commissioners of Johnson County v. Nick Jordan and David Harper, respondents. Counsel, after you state your appearance, as was done in the prior case for the benefit of our students, if you could give maybe a 60-second factual overview so they understand the background of your issues.
Most certainly. May it please the court, I am Catherine D. Myers. I'm Assistant County Counselor for Johnson County, and I am also acting on behalf of the other 20 boards of county commissioners who have brought this matter before you today. This matter involves the question of the constitutionality of a statute passed by the legislature effective July 1, 2014 that added a language that if an owner of property appeals their taxes and they are successful in that appeal and receive a reduction, that reduced value will be maintained on that property for the next 2 succeeding years unless the appraiser has substantial and compelling reason to raise that value. The legislature then went on to define in a new subsection C of that statute what substantial and compelling is, and it is either a renovation or an expansion of existing improvements. It does not mean, according to that subsection, any type of repair or maintenance to the property would not justify raising the value in the next 2 succeeding years. The petitioners have brought this because 2 reasons. One is under the Constitution, Article 11, Section 1, the legislature has been mandated to provide a uniform and equal basis of valuation and taxation of all property. That is the language that went into Article 11, Section 1 when it was amended in 1986. Prior to 1986, the word valuation was not included in that phrase, although that phrase has been in existence in that same substantial manner since the Constitution was adopted on this day. They also did this because prior to 1986, and for a very good background on what was happening at the time, there is a law article in the Washburn Law Journal, volume 29, that discussed what was going on at the time. Our system of taxation in the state was very ununiform. You could have similar situated properties in different counties being taxed at very different rates, anywhere from as little as 5% of the assessed value to as much as 41% of the assessed value. There was really no uniformity among the counties and statewide on how values were being set and then consequently taxed. So the new amendment created specific property classifications, and within those property classifications set a standard rate of assessment. And in addition to that, the legislature implemented a number of statutes and amended a number of statutes, whereas from that point forward, all real property was to be valued at fair market value. It is to be done annually. You are to assume a sale as of January 1, so we are working on a calendar year. And it's to be valued at fair market value, which is an assumed sale between a willing seller and a willing buyer, both parties fully informed as to the circumstances of the transaction, and neither party are under any type of duress or compulsion to enter into the transaction. So we are talking about looking at the value of property based on what the market is dictating properties of this type sell for. That is in 79503A. There are also currently 11 factors listed in that statute that the county appraiser is to consider in arriving at fair market value. Those factors essentially mimic the types of things that an appraiser would do in applying the three traditional approaches to value, which is the cost approach, the income approach, and the sales comparison approach. It also further requires that you must use the generally accepted appraisal practice in implementing those approaches to value, adapted to mass appraisal. So we are not looking at what one individual property might be worth, but we are looking at what a universe of properties that are similar, generally what they would sell for in the market.
Counsel, can we talk for a minute about the appropriateness of mandamus as an avenue for your clients here? And specifically, I'm interested in the delay between effective date and the filing of the action. Can you give us any information about why it was more than a year?
Well, for one, the substantial and compelling does not come into effect until you have gone through the 2015 valuation year, which we just finished. And that is because the change to a 2-year from the previous, which was 1 year, with an undefined what was substantial and compelling, affected the taxation of property, the valuation of property for the 2015 tax year. It couldn't have been, even if the legislature wanted to make that retroactive to the 2014 year, when the statute went into effect on July 1, 2014. By that point, the appraisal process had been completely completed. The informal hearing process, where the taxpayer comes in and talks to the appraiser or to a designee of the appraiser, those hearings must be completed by May 15th. So those were completely completed. And most people now, if they had not reached a satisfactory decision with the local officials, would now have already made their appeals on up either to the small claims, especially if you're a residential, you have to go there first, or they would have their appeals already filed with the Board of Tax Appeals, because you have to file within 30 days of your informal hearing decision, and that was May 15th. So by that point of time, property for that tax year of 2014 was already well into the appeals cycle for that year.
But those steps were going to happen anyway. I really think what the question goes to is, wasn't the battle joined on July 1 of 2014 when the statute went into effect? I mean, you know then all the other dominoes that are going to fall between then and now, and you waited until November to file this action.
Well, first of all, I am unaware of any situation where the challenge to the constitutionality of a statute has a time limitation on that.
Not the challenge, but the challenge via mandamus. Mandamus has a speediness side to it.
Correct.
That's why we're asking.
Correct. And during the time after that legislation was enacted, we had another legislative session that was going on. There was still a great deal of talk during that legislative session to making even more changes to the tax statutes. One of the bills that was actually put forth in the House Committee on Taxation was to change the property tax system so that valuations would no longer be on an annual basis, but would be on a biennial basis. If that had occurred, much of what we're talking here today might have become moot. The other part of it is there was a lot of talk among the various entities that will be affected by this, who have to administrate it, and who rely on property tax for a major part of their budget, is trying to reach some sort of a consensus, if there was any consensus, on what should be done. Nobody really wanted to be the only person who put their neck out there, and nobody at first could really agree on what was the appropriate way to even do it. Some counties did not join into this action because they planned to challenge it in a particular taxpayer appeal, for instance. We, as a group, felt it was much better to come here directly and put this before the court so that we could be ensured that we would know statewide how the statute, whether it should be implemented as it's written, should not be implemented as it is written, and wanted to do that in such a way as we could get it here as quickly as possible. If we had gone the route of a declaratory action, for instance, I would probably only just now be getting here as it is. And we also didn't want to put any taxpayer in the position of being a focus in this matter.
One of the other questions I had on the theme of appropriateness of this original action has to do with why you brought it as a mandamus instead of a quo warranto. Because we do have original jurisdiction to do that, and it seems more appropriate that when the property valuation director is telling your county appraisers to do something a certain way, that the proper response is to say, well, by what authority, which is quo warranto, by what authority do you tell us to do something? And instead you brought this as a mandamus, and did you see a particular benefit to mandamus over quo warranto, or did you not consider quo warranto, or where are we on that?
We looked at both, yes, and there is no doubt that the Director of Property Valuation has tremendous authority over the valuation process. I don't really know of any other state official who has so much authority over a local government employee. The KSA 79504 allows the Director of Property Valuation to issue directives to the county appraisers. There's plenty of case law that says that a directive is the same as a regulation, and the county appraisers are bound to follow that directive. So as far as a quo warranto is concerned, yes, he has authority to issue the directive. But he also has the authority of being a gatekeeper to the taxation system as a whole. One of his duties in 79-1404 subsection 10 is he is to continually evaluate the tax assessment system and to be on the lookout for anything that may be defective to the entire concept of uniform and equal valuing property at fair market value, and to take appropriate action if he believes that there could be an issue, either with statute, administration, whatever that may be. And we did meet with the property director. It was a friendly meeting. We are not here as antagonists with each other. But the counties did put forth their concern that we had concerns with the statute, that he had entered a directive that said we had to comply with it, even though during the session in 2014, in the original bill that became the substitute for the bill that enacted the legislation, this language was in there, and the Department of Revenue was on record that they had questions as to whether or not it was constitutional. But the director has made a decision, which is within his right, not to take it upon himself to challenge whether or not the statute is unconstitutional. So we believe that not only is it unconstitutional, but the director had the ability to do that. He knew there were questions about it, and he was refusing to act on it until a court tells him otherwise.
Let's take the next step in the process here. I'm sorry, did you?
No, that's fine, go ahead.
Let's take the next step in the process of whether you can even be here. Let's assume the statute's unconstitutional. Why does the Board of County Commissioners have any standing to object to it?
The Board of County Commissioners are charged with hiring the county appraiser. The county appraiser is hired by them on a 4-year appointment. At the end of 4 years, they do not have to retain him anymore. Once they hire him, they are responsible for his budget. They pay for all of the necessary expenses that the office requires in order to value all of the real property within their county. Beyond that, they are also the ones who are responsible for determining the budget for the entire county, and that budget relies heavily on real property taxes. If the county appraiser does not meet the expectations of the director of PVD, for instance, just refuses to follow the directive, the director of PVD can have the appraiser removed. The person that the county has chosen to be their county appraiser. And then PVD can come in to the county and take over the office and run it however they wish to, but the county Board of County Commissioners, they still have to pay for the budget of that and have no control over how much money the director of PVD might incur if he were to take over the office. And this would be the case in all 105 counties. So they have a direct interest in this because it can adversely affect their very own employee that they have personally chosen to have the position and for whom they are entirely financially responsible for. And in turn, the appraisers, because they have a 4-year appointment, they can only be removed for cause. If they disobey the director's order, as I said, he can come in, have them removed. But there also are all these auditing and compliance procedures that have to be met, and one of them is the sales ratio study, which is based entirely on what is the property in your county selling for on the open market, and are your values consistently within about 10% high or low of that selling price. If you are holding values for 2 years after a reduction and they are not subject to being valued in the same manner as other property is in the county, which is under 503A, 79-503A, you could have issues on whether or not you're going to be able to meet your sales ratio study. And that's a real problem in counties who do not have lots of sales, for instance. Johnson County, for instance, we have plenty of residential property sales. Probably not such an issue with residential property. But even in Johnson County, the sales for a commercial strip center or an office building or whatever it may be, they're fairly limited. You might only have 10 office buildings sell in a year. And you could easily have 10 office buildings that have a reduction in their value in a year. So there's a very real possibility you would not be able to make your sales ratio studies at some point because of this mandate to hold the value. They also, both of them, take oaths of office, to uphold the Constitution of the United States and of our state. And it's an oath that they take seriously, and they all have to take that as well. So it is an issue that affects the legal status of the appraiser and of the Board of County Commissioners. It applies to every county in the state, not just to the petitioners herein. We are talking about a situation where we could be talking about a lot of money at issue here. And real property taxes are the basis for most local government functions.
Counsel, you're closing in on finishing the first part of your argument, so I want to move you, if I can, to the standard we should employ to judge constitutionality here. It looks like you've taken the position that this is just kind of your traditional rational basis test under equal protection analysis. Is that your position?
I believe it's a rational basis test, yes. That is the indication I get from the cases that I have read from this court in the challenge of an Article 11 matter.
How does that square with the farm machinery cases from the early 80s where admittedly the constitutional provision talked about uniform and equal assessment instead of valuation, but I don't see a difference between the word assessment and valuation the way we use that. And I don't see the application of the rational basis test. And I also think that the farm machinery cases are pretty much square on point with the problem that you're raising here. So, I mean, I wasn't sure in your reply brief whether you weren't backpedaling a little bit off of rational basis, because you do cite the farm machinery cases.
I love State versus Martin as a comparison to this situation for a lot of reasons. That issue on the farm machinery and equipment arose because the market was going up and going up significantly. And farmers, small farmers, were complaining about the amount of taxes they were having to pay on their farm machinery and equipment. PVD was charged with determining what the fair market value was of that equipment. There was no issue that PVD wasn't doing its job in arriving at a fair market value for that equipment. And much of that equipment doesn't have to be used in a farm operation. You can use that equipment in other types of industrial applications. So you had a situation where you could have a farmer with a particular piece of property and somebody who maybe was in construction who had the same piece of property, but they would be taxed at a different value. And the argument was tried to be made that the 20% off was its fair market value. The court rejected that and rejected it on the fact that you had similarly situated taxpayers using the exact same type of equipment. One would be taxed at a value that was 20% greater than the other. And they looked at it as a partial exemption.
I know the facts.
Yeah.
I'm trying to figure out whether the case, that factual scenario is the same as the factual scenario you have here.
It's a partial exemption. This statute creates a partial exemption to taxation. The only way to raise the value under this statute is if the owner makes a substantial change to his property. It's a factor entirely under his control. No outside factor can be taken into consideration to raise the value of that property.
Okay, so assuming similarity, assuming that factual similarity, is the standard that was, if you could return to my question, is the standard that was applied in those cases the same as rational basis under equal protection, just conventional rational basis as opposed to something different?
I do not see it as anything other than the legislature can create exemptions that aren't in the Constitution. They can do that if it meets a general welfare for the people as a
The
whole.
legislative discretion to do that isn't contained by the basic concept of fair market value?
It is here, and it was there. Yes.
Okay, so is that at least a gloss or kind of an overarching principle that modifies regular rational basis inquiry in equal protection cases?
All of the cases that I have read seem to me to conclude that regardless of the rationale that the legislature uses, if you are treating otherwise equal
Similarly situated.
similarly situated individuals different, regardless of the reason for that, it does not meet uniform and equal, period. It's been called insidious discrimination in some of the cases I have read. The language from the Waitman case, which was, I think, 1920, is repeated in every case that I have looked at regarding uniform and equal and when a statute violates that concept.
There's another way to look at, I mean, you describe it as a partial exemption, and I understand that argument. There is another way to look at what the legislature was doing here, and that is that they were creating a penalty rather than an exemption. In other words, the legislature could have said, look, we have an interest in making sure that valuations are accurate, and we're suspicious that valuations maybe aren't always accurate. So we want to create an incentive to the valuation officials, i.e. the counties and their employees, to get it right the first time. And if they don't get it right the first time, we're going to impose a penalty. If we look at it that way, does that change the standard that we use? Does that alter our analysis in any way?
No.
Why not?
That is actually touched on in that State versus Martin case, where the court quoted from the Supreme Court case out of Little Rock, Arkansas, that had come up to them through the Little Rock, Arkansas the Arkansas Supreme Court. At that level, at Arkansas Supreme Court, that court stated that you cannot use discriminatory measures against taxpayers under the guise of regulating assessors. And there's a good reason for that. First of all, you're not penalizing the appraiser. You are penalizing the other set of taxpayers who just did not go through the property tax appeal process for whatever reason and or weren't successful. That's not to say that the values for all those properties were or weren't correct. It's not to say that the value placed on the successful taxpayer was or wasn't correct. But you have created now two sets of taxpayers who are going to be treated differently because one opted to appeal, one did not. And the idea of the property tax system is you value the property and how much the property is worth.
It sounds like from your argument that if what the legislature had done was say, as a matter of statute, we are going to allow a successful property owner who successfully appeals to collect as a penalty any amount of valuation increase in his property taxes for the next 2 years. So the valuation remains the same. They're not locking it in for 2 years, but the successful property owner gets to essentially collect damages against the municipality. You're saying that you would not have a problem with that?
I think that could be done, and actually that was done not in that direct manner, but when the legislature amended KSA 792005, they added a subsection in there where now the counties must pay out of their general funds interest on those refunds. And that interest starts as the day that they begin their appeal process. And that was done explicitly for the reasons you were saying.
Okay.
The other thing the legislature could do if it was concerned about enforcing this on the counties would be to assess attorney's fees for successful property appeals, right?
Yes.
But it can't be, what we have here in this statute can't be cast as a penalty on the county or on the appraiser because it doesn't change the county's budget. Doesn't change anything about the county. All it does is move the tax burden from one property owner to the other property owners. Is that right?
Exactly.
Let me focus you in on the 2014 legislative session where this bill that we're looking at, this statute we're looking at, was enacted. It did two things that were different from what had been going on in the past. Because for, I think what it was, 20 years or something, when you had a situation where a property owner successfully appealed a valuation, they got the value of that for the tax year that they won, and then for the next year. And then there was this amorphous term that said unless there's substantial compelling reasons, but nobody bothered to define that, so it was sort of in the ether. In 2014, the legislature doubled the number of years, went from 1 year to 2 years, but then also ratcheted down the definition of substantial and compelling to limit that feature. My question to you is if we find, what's unconstitutional about what happened in 2014? Is it going from 1 year to 2 years? Is it the new definition of substantial and compelling that handcuffs the county appraisers so much that this becomes unconstitutional? Or was it even the original statute? And I'm asking that is because if we get into the ground of this being unconstitutional, we have to consider whether severance is in play. The property director and the Secretary of Revenue have said, well, we ought to just sever a little piece. I'm trying to figure out what we sever and whether this is fixable just by taking out the definition of substantial and compelling, which in effect, if I understand the facts, would put you back to where Attorney General Stovall said the law was back in '91 when she was trying to figure out what substantial and compelling. You see what I'm getting at?
Yes, I do.
So
Yes, I do.
what's your remedy?
It is the position of the petitioners that even the 1 year hold and having to have a substantial and compelling reason to raise the value was unconstitutional. Now we all understand that when you're talking about challenging a statute and you're talking about a legislature who has the ability to control your tax lids, et cetera, political considerations come into play. And at that point in time, nobody challenged it, primarily because of those reasons, to be quite honest.
What
I know-
reasons? Because of what reasons it wasn't
There were
challenged?
political considerations at play at that time. My contention, the petitioner's contention is it doesn't matter if it's 1 year or 2 years. If it can be 1 year or 2 years, why can't it be 3? Why can't it be 4? Why can't it be 5? This almost was a 3-year hold. It was amended on the floor of the House to 2 years. It went to the floor with the requirement it was going to be held for 3 years. If this court were to find you can do it for 1 year or 2 year, that's just a green light that you can do it for 3. There has to be some sort of a bright line here, and the bright line is the Constitution. You can't treat a subset of taxpayers differently than otherly similar situated taxpayers. Everybody who's being assessed as at residential should be valued under the same guidelines, period. And those guidelines are in 503A. So when they went to the 2 years, without any explanation other than complaints of appreciation in the market, and we got to do something about this, and we need to define substantial and compelling, at that point they did. They just really tied the hands of the appraisers. There really is no way to apply the factors in 79503A the way it's intended to arrive at fair market value, you have to have either a renovation, a substantial change in the actual physical characteristics of the property. And that is just one piece of all the factors that go in determining fair market value.
Is that fair market value standard statutory or constitutional?
The legislature was charged with setting up the scheme for taxation to be uniform and equal.
Right.
And they did.
And they did that by statute.
They did that by statute.
The question then, we circle back to the question of by what standard do we judge? And I'm hearing two different things from you. On the one hand, I'm hearing yes, rational basis, but on the other hand, no, bright line rule, you can't vary at all. And that's not rational basis. And the question is, can the legislature can they vary the means of valuation at all? And if you're saying no, there's just a bright line rule, where do you get that from?
They can, but they have to do it for every taxpayer within that particular classification.
Well, if the
standard.
classification is taxpayers who successfully appeal on the one hand, and taxpayers who don't successfully appeal on the other, they're treating each of those classifications within the class equally and vis-a-vis each other unequally. And the question is, can they do that, right?
The classes are defined by the Constitution. You have your residential property, they're all to be valued under 503A at 11.5%.
What you're saying is the classification is of the real estate, not of the taxpayer. Is that what you're
Yes.
trying to say?
Yes. We're valuing the property. And the fact that my property is just like your property, but you appealed and I didn't, and you got a reduction, does not justify you getting to keep that reduction for the next 2 years while I continue to pay just like everybody else under 503A. You can change the method, the taxation scheme for the classification in the Constitution, but you have to do it for everybody that falls within that assessment
So
class.
that's not a rational basis review.
It would be, I guess you could say it's a heightened scrutiny. I didn't read any case that actually came right out and said heightened scrutiny.
It's not any of that, though, is it? I mean, if you look at farm machinery, the 1980 case, it was a bright line rule. If it's the same property, then you have to value it the same way, regardless of the circumstance of who owns the property.
Yes. Yes.
And to follow up, just so I'm clear, if we apply that bright line rule, we don't move to any rational basis analysis.
No, I guess you don't.
It's almost strict liability. Isn't it?
Yes, I guess it is. Very much like that. I mean, there was a very good reason for why that phrase was put into the Constitution from day one. So we don't want to allow the legislature to set up a system of taxation that might favor a group simply because of who the people are within that group. Each man, from the right case, each man has the same interest in maintaining their local, their state, their federal government. And each man is equally obligated to the proportion of the value of his property to help fund those governments. And in return, those governments are to protect the welfare of all of those citizens equally.
Do you have any further presentation?
No, sir. Thank you.
Any more questions? Thank you, counsel.
Amelia Kovar Donahue with the Department of Revenue for the respondents, Nick Jordan, Secretary of Revenue, and David Harper, the Director of Property Valuation. Respectfully, Mr. Chief Justice, I'm here to address the constitutional issues related to the case before you today, and I would like to request 3 minutes be allocated to Ms. MJ Willoughby, who is also co-counsel, to address the jurisdictional questions of mandamus and standing.
That's acceptable. Thank you.
Thank you. May it please the court. What's interesting is that many of the questions that you raised with the petitioners this morning are actually how I outlined my presentation today. So I'm going to go ahead and start with, and we kind of backed off of it a little bit, but I'm going to try and bring us back. There's no dispute in this case, at least in the briefing, that the test in this case is the rational basis test. However, understanding what the rational basis test is and its proper application are key if you reach the merits of this case. I have 4 specific points that I want to address. The first point is that the courts have consistently held that when a challenge is made to a tax statute as violating Article 11, Section 1, our uniform and equal provision in our Kansas Constitution, the rational basis test is as follows. Does the classification bear a rational relation to the purpose of the legislation? That's the question. The question is not a more ubiquitous, is this uniform and equal? And the question isn't, does the statute treat every single property exactly the same? The question is, does the classification in the statute bear a rational relation to the purpose of the legislation?
You get there in your brief, as I understand it, by citing to property exemption cases, and you don't even reference the farm machinery cases.
Right.
And I thought that was an interesting omission.
And actually my 4th point today was going to discuss the Martin line of cases, which include the farm equipment and machinery cases.
Let's talk about it.
So let's move to point 4. Point 4 was actually that I was, in my opinion, in the respondent's opinion, the Martin test is not the prevailing law. If you look at that test in Martin, it wasn't a rational basis test. Right? It looked at fair market value as it was set forth in 79-503 at the time, which now is 503A. And it said if it doesn't meet those factors, then it's not uniform and equal. I think what's interesting is at that time, the Supreme Court was also starting to hear some cases, specifically a Tomasic case in 1981.
A tax exemption case, I think.
A tax exemption case that went and talked about the rational basis test. It went through the 4 exemption factors and also looked at the rational basis test. I think where I distinguish the Martin case is that it forgets the premise that fair market value is in a statute. What the Constitution does is it tells the legislature to provide for a uniform and equal basis of valuation and assessment. And then it is up to the legislature to adopt the statutory provisions to do that. And what they have done up until this point is they've adopted 503A, and then we have some other provisions that set forth what fair market value is and those factors. It follows then, though, that the legislature then has the ability to amend that statute. And I think then, at that point, if they decide to amend that statute, they amend the definition or the factors that go into it. The question is, are those amendments rationally based? I mean, it's not a test of, I think the legislature has that same ability to amend the statute.
They always have the ability to amend a statute. I mean, that kind of goes without saying. We know that, but they have to do it in a constitutional manner.
Right, and then you get to the rational basis test. We
I
don't fall
think-
back
I-
on the
I
factors of
wonder
a
about-
statute.
I wonder about that because our court has, for a long time, talked about the uniform and equal assessment or valuation, depending on which year you're looking at, as being a constitutional command to the legislature. And you seem to be saying that when the Constitution says that the legislature shall provide for a uniform and equal basis of valuation, you want to add the words, unless the legislature has a good reason not to. And that's what I'm seeing in your argument. So where am I wrong?
No, because I think this provision, this 79-1460, is uniform and equal. It meets a rational basis test.
How? You've decided that a successful appeal by a property owner freezes the valuation of a piece of property for 3 years, unless they meet one of these restricted, substantial, and compelling things. Let's just set that aside for a second. You've said that freezes the valuation at the tax year 1 for 3 years. All the rest of the property is being valued based annually on value tax year 2, value tax year 3. That's not uniform and equal.
Well, and I think there's two ways you can look at it. The first way is that you could look at it as amending the definition of fair market value, but the other way to look at it is that it is a partial exemption.
Well,
And that's when you get to the partial
It can't
exemption
be
question.
amending the definition of fair market value, because then it's not uniform and equal. You have a definition that applies for two houses side by side, and one definition of fair market value applies to this house, and one definition applies to the other house, and that's not uniform, nor is it equal.
But there's lots of factors that go in. I mean, if that's the conclusion of the court that it's not fair market value, then I think it becomes an argument then, was it a permissible partial exemption?
But
I
your
think that is
limit,
another way to look
but
at
the
it.
Constitution limits the ability of the legislature to even give exemptions for property, certainly not partial exemptions. I mean, again,
But
the farm machinery case said you cannot, when they were just deducting 20% off of fair market value, the farm machinery case said you can't look at that as a partial that it is a partial exemption and it's unconstitutional.
Right, and they made that statement. But what's interesting is after that case, in both Von Ruden and specifically Tomasic versus Kansas City, Kansas in 1985, it's at 237 Kansas 572. There actually was a question of the partial exemption question, and it had to do with the industrial revenue bond exemption that's provided in 79-201A second. And that partial exemption was in fact upheld as constitutional.
And did it apply to valuation? That's to
But
me.
it- but it
to me, the
does.
farm machinery cases are valuation cases, and the other cases that you cite, the later ones that talk about rational basis, are partial exemption cases and income tax cases, and those are different. It seems to me than the constitutional command for a uniform and equal basis of valuation.
But the question still remains, is the uniform and equal constitutional provision is a rational basis test. There's numerous cases that find that.
But
it's not that the legislature has adopted fair market value as that basis. And I think it's well within their realm to further amend that definition and maybe provide exceptions or other factors to be considered, so long as it meets the rational basis test.
You're basically relying on some of the language that would indicate that the interest that is protected by Article 11, Section 1 is akin to the interest protected by the Equal Protection Clause.
Yes.
and that because we apply rational basis to classifications under the Equal Protection Clause, we would equally apply rational basis to any classification of what I think clearly is an unequal or at least a non-uniform method of valuation. Do you agree that this is a non-uniform method of valuation? I mean,
No.
well, why not? When you've got let's just take year 2 as an example.
Okay.
Year 2, you've got 2 classes: successful appealers and everyone else. Successful appealers get a valuation method that just locks in the old valuation. Everyone else gets a new valuation. And that's non-uniform, isn't it?
Not if there's a rational basis for those two categories.
Right, but we get to rational basis when we have a classification.
You have to start with the similarly situated who have different rules. That's how I think Justice Stiegel was trying to get you past that point.
And I don't think those two properties are similarly situated. Because one of those properties had been overvalued, and the burden was placed on a taxpayer to appeal the value to get to fair market value just like everybody else.
So if that's your argument, then whether rational basis applies to this particular constitutional provision or not is really irrelevant, because we shouldn't be in equal protection law because there's no classification of similarly situated people in the statute. In your view, there's no classification that divides similarly situated people, because you're saying they're not similarly situated. I'm just confused about where you're jumping off the train here.
Well, I just don't see how, I don't see that they're similarly situated people, or, similarly situated properties.
And if you don't have similarly situated people, you don't even have the beginning of an equal protection claim, or, in your view, a claim under this provision of the Constitution. Is that right?
And there's no reason to apply a rational basis test.
We don't have to get there.
That's way down that road.
Okay.
Not sure?
All right.
Okay.
Sure.
Not sure.
And
Okay,
what
let me
about-
ask you a different question, if you don't mind. Or did you get enough of an
Yeah,
answer to your
go
question,
right
Justice
ahead,
Stiegel? I have another question, if you don't mind, Justice Johnson, real quick here. I want to just, for a moment, walk down the road that was suggested by Justice Stiegel earlier. What if this is really designed to be a penalty? This question was posed to your opposing counsel. Does that have any impact on do you think that would qualify? Assuming we're in equal protection land and assuming we're applying rational basis, do you think the motivation of the legislature to have a penalty would be a rational basis? Sufficient to satisfy the analysis?
I think, as opposing counsel pointed out, I don't see it as a penalty.
I'm saying assume it is. Not sure, right?
Well,
I mean, I'm just moving things along. So not sure?
not sure.
Okay, so what is the rational basis that justifies it here?
If we look at least what was before the legislature at the time, it appears that they were looking at the time, expense, and those types of things that particular property owners were required to expend to challenge the value of their properties, that they felt they were overvalued. The Board of Tax Appeals or the district court agreed that it was overvalued, and they were granted a reduction in value. And it's not whether or not the legislature actually cited those reasons, but are there conceivable reasons? I think also, there's a conceivable promotion of fairness in the valuation appeals process,
So
at
the
least in the eyes of those taxpayers.
So the purpose, and we've got to establish a purpose to use your test, right?
Mm-hmm.
The purpose was to encourage appraisers to value appropriately, or to reward the landowner that challenges in order to keep the appraisers honest? Or, I mean, I understand that it costs money to challenge your valuation, but what is the purpose of freezing then past that determination?
If you look at the legislative testimony, I think that the basis was promoting consistency and predictability for those property owners who have gone through this process and received a fair market value of their property that was lower than what the county originally appraised the property at. They talked about that being very important to commercial taxpayers as well as homeowners, that there's stability and consistency there.
In
And
the
you
farm,
achieve-
I'm sorry, go ahead, Chief.
I was gonna say, and you achieve that predictability by extending that corrected value for several years in the future. Is that what you believe the legislature was driving at?
It may be.
Well, I thought you indicated there was some testimony or some legislative history that said they were looking for predictability and consistency.
Yes, that's what the testimony was.
Well, what would prevent, without this, the appraiser coming in the next year and on a successful applicant coming the next year, where we're going to set it back where it was, and then the next year back where it was? Could that also be a reason to, again, the predictability and consistency, to not allow any kind of vindictive kind of action on a successful appeal?
Yes, I believe that could be a reason, and I think there is, whether it be a Court of Appeals opinion, that has actually pointed that out as a possible reason
Right.
for at least the original version of,
Right,
of this,
back to the
of this,
one-year one.
of this legislation that we're talking about, right?
In the farm machinery case, the justification that was used by the Department of Revenue was that, and in the farm machinery case, we gave a 20%, the legislature gave a 20% reduction in the valuation of farm equipment and machinery, and the justification for it was these are tough economic times and we like farmers. So why doesn't that fit?
I think today, after the evolution of many of the Tomasic cases out of the Wyandotte County area, and again, this is an exemption issue, but I think we get to the point where the legislature has taken the position that the public interest and the public welfare is benefited by the economic prosperity of commercial enterprise in the state.
Do you not like farmers?
Well, but I think that's equally true of farmers. I think if that case were heard today, I don't know if the same opinion would be made.
Does that mean we have to overrule the farm machinery cases in order to hold in your favor?
Possibly.
I had another question, taking you off this completely.
Okay.
Maybe that's a good thing. One of the exhibits that the respondents attached was the directive for 14-047, the last directive from the property valuation director. And there's a statement in here on the second page, the first bullet point, that says county commissioners serve as the client and the taxing districts are the intended users of appraisals. I'm trying to figure out what that means.
I was looking for a copy of my.
It's your exhibit 1.
Can you direct me to the page you're on? I apologize.
Yeah, it's page 2. It's exhibit 1. You have that, I think I see. Look at page 2, the first bullet point, and about a third of the way down in that paragraph, it starts, therefore, county commissioners serve as the client. Now, this is a directive to the county appraisers.
Correct.
And so it says the county commissioners serve as the client, and the taxing districts are the intended users of the appraisal. I just wondered what that means.
Okay, this directive is explaining how the USPAP standards, the Uniform Standards of Professional Appraisal Practice, should be applied in the realm of mass appraisal, which is what the county appraisers are doing. In the world of appraisal, there are mass appraisals, which usually public entities, counties, cities do. And there's also single property appraisals, which are those fee appraisals you see when you buy a piece of property, you know, that the bank uses for financing. We're in the realm of mass appraisal, and USPAP standards actually talk about mass appraisal, and they also give numerous guidelines about what needs to be in an appraisal. And one of those items is you need to list an intended user. And so what this is saying is when a county appraiser does a mass appraisal, the intended user of that mass appraisal is the Board of County Commissioners.
They are the client,
They are the client. Yes.
using the appraisal methods that the property valuation director is imposing through a directive like this.
Yes.
Do you have any more questions?
Can you briefly, just not explain, but just briefly state your other 2 points?
Oh. My second point was just to point out that separate from rational basis, there's also a line of cases that talk about uniformity and equality, and the fact that the Kansas Constitution does not prohibit exemptions, and that the legislature may provide for exemptions so long as they have a public purpose and promote the general welfare. And my third point was just that in our opinion, the statute does satisfy the rational basis test. And if I may, I have one other clarifying point that wasn't one of my points, if I could have just 1 minute.
I'll time you at 60 seconds.
Okay. It has to do with the state. There's some concern apparently in the petitioner's reply brief relating to the sales ratio study and the fact that that's used to determine substantial compliance for county appraisers or for county appraisals. And I just want to point out that if this statute were to be found to be constitutional or the case is dismissed, these concerns about the sales ratio study can be addressed administratively by the director and PVD to allay some of those concerns. PVD's review of the appraised values, when they're looking at appraised value and sale data, they can identify these properties and take into account whether or not they should even be included in a sales ratio study. The second way is that a county could, once a county receives their list of properties that are going to be in their study, they could notify or appeal to the Division of Property Valuation and ask that those properties not be included in their sales ratio study. But we are willing to work with the counties to allay that concern if they feel like there's still some substantial compliance concerns.
Very well. Thank you, counsel.
Thank you.
I do have one other question. The question I'd posed to council about, is there a way to, if we get into the statute being unconstitutional and we have to consider severance, you guys have brought up the notion of severing this piece, but I've been thinking about the idea of, is it possible to save this statute by just taking out the restrictive definition of substantial and compelling reason? In other words, one of the purposes I read in your material that the legislature was interested in was putting a burden on counties to sort of really come forward with good evidence if they're going to change a valuation from one year to the next after a successful appeal. I see part of the, and again, it gets back to Attorney General Stovall's opinion that you also attached there. It seems like she saved the statute back in 91 by putting a little extra play in the joints on what substantial and compelling meant. So I'm wondering is whether one possible remedy is to strike that definition so that there's more flexibility at the county level, not complete flexibility, but more flexibility on being able to raise those values.
If you agree with Attorney General Stovall's opinion, which we did at the time, that it was still possible to achieve fair market value, then yes, I think uniformly and equally, that yes, by removing the substantial and compelling reason definition, I think would take you back essentially to the prior version
Well, it'd be
of this
2 years
law.
rather than
But
1
it
year.
would be 2, and they would have that burden for 2
Right.
years instead of 1 year when they value those properties. They have to provide that documented substantial and compelling reason to the property owner.
Right.
Any more questions? All right, thank you, counsel. Counsel, there's 3 more minutes of argument.
Oh,
No, I'm sorry.
Oh,
She
I'm
has
sorry.
the floor. And while you're up, was there a reservation rebuttal time?
When you asked me to explain the case, I think I forgot to ask for it, so.
Yeah, I did not have it in my notes, and I'll double check our teachers. Mario.
May it please the court, MJ Willoughby, Assistant Attorney General's additional counsel for respondents, Nick Jordan and Director Harper. Question of jurisdiction. Mandamus is not a common means of obtaining redress, but is available only in rare cases and as a last resort for cases which are really extraordinary. And those aren't my words, those are the court's words in denying a writ of mandamus against Judge Steve Becker and State v. Becker, 264 Can 804 807, 958 P. 2nd, 627, 1998. This court, Justice Biles and Justice Byers' questions hit upon the fact that's very much admitted by petitioners that they could have easily have brought this in Shawnee County District Court. It could have brought it July 1, 2014. And actually, in their view, this has been unconstitutional since 1992. They just deemed it more efficient to come to this court. And we know in this court's rules and jurisprudence and its rationale about original jurisdiction, and in Justice Rosen's opinion in the Solomon case, in the conclusion of it, that a separation of powers in the system that we have isn't necessarily about efficiency. The question is, and the other thing they've obscured is what they really want here is a declaratory judgment regarding the constitutionality of a statute. And they could have filed this under the Declaratory Judgment Act, and the cases they cite regarding standing are cases under the Declaratory Judgment Act, not mandamus cases. In terms of this kind of case, the case law in Kansas is pretty clear that the Attorney General is the proper person to bring this kind of case. So littered through these cases is State ex rel so-and-so versus so-and-so. And those are all Attorney General or Nick Tomasek. And the Attorney General is the proper person to bring these cases. For people who are not the Attorney General, a different standard applies. And it's a showing of a particular and unique injury, which was the question in the case that the Kansas Bar Association brought against the judges of the 3rd Judicial District, which would have been Chief Judge Lukert at that time, and Judge Rosen and Justice Larson went at some length in discussing, in that case, what's required for that kind of mandamus action to obtain relief against the constitutionality of a statute. So in this case, in the petition, if you have that unique injury, where does it need to be displayed? And it should be in that petition, and it's not in this one. Now the question is, can the courts apply interesting allegations? Can it come up with some ideas? And this is an interesting question. We'd like to resolve it. Well, that puts the court in a difficult position. And if we were in the district court, we would have months and years to come up with a developed case and arguments, and the burden would have been on the parties to do that. And by shifting this and bringing it in such an expedited way to this court, it doesn't allow the proper development. Anyway, I see my time is done.
Do you think the board could have brought this in district court?
Yes, Shawnee County District Court would have been the usual way of bringing it.
Well, let me, in the case law that you quote in your reply, you say that mandamus is appropriate as an original action when, and number one, an issue of law affects public officials. Number two, presents an issue of great public importance and significant state interest. And three, requires a speedy adjudication. Now, which one of those doesn't fit this lawsuit?
I would say all three. In terms of the speediness, as you pointed out, the questions that you and Justice Breyer asked, there was no need to rush in here on an expedited basis. I mean...
Well, the valuations, as I understand it, have to go out on March 1st. And I'm not particularly happy that this came up on November 1st instead of earlier, because I think the battle was joined when the statute was done. But delayed, I don't see how that enters into the speedy adjudication. We have valuations that are going to go out on March 1st, and they need to be done in a uniform and equal basis according to the Constitution. So that would seem to require a speedy adjudication.
But it's, yeah, a manufactured speediness on behalf of petitioners through their delay. Now, in their view, this has been unconstitutional since 1992.
So you're kind of applying an estoppel or latches kind of argument. What about the other two? An issue of law that affects public officials, you say that doesn't apply?
No, in the sense that there are other cases that talk about the court doesn't exist through mandamus to resolve disputes between public officials. And in the mandamus cases...
Doesn't it say just the opposite? I mean, I was in a ton of those cases back in the 80s, and it says just the opposite, that when public officials need guidance for how to perform their official duties, and this would seem to be one of those, that it's an original action may be appropriate. Now, it's still discretionary with this court, but it may be appropriate.
Well, exactly, and this is where I do agree with you, that the court does have discretion on these matters, and as this court struggled with recently in the State Ex-Roachment versus City Wichita, that question of when and how to exercise that original jurisdiction, and which questions to answer, and which questions are properly framed to be answered. That is a very important question that actually you all can only answer. And I will agree with you also that if you look at this case law, it does depend on the facts and the circumstances. And it's kind of like obscenity, and the question is this case that important that we need to reach out there and grab it? And in terms of determining whether there is great public importance or great public interest, how is that determined?
How is there not great public importance and, well, let me use the exact language, public importance and significant state interest in this case? It seems to me to affect literally every piece of real estate and the tax burden on that real estate in the state of Kansas.
Well, there's two questions embedded there. In terms of the petition, and it's kind of contradictory. On the one hand, the petition that was filed says that really we're talking only a very small number of taxpayers who actually appeal their property valuation and are affected by this. We're also talking about what was a 1-year freeze is now a 2-year freeze. So that the question of significance. And then the flip side of that coin is if this is a matter that affects everyone in the state and all taxpayers, then who is the proper party to seek this kind of relief? And generally that's the state attorney general. And that's also how we know that it's of great public importance and significance, because the state attorney general has been here maybe twice, in this attorney general in our memory. And, you know, he or she does not spend their capital recklessly coming over here with questions to challenge the constitutionality of statutes. So in one way, it's a way of maintaining this court's, a limitation. Like why these counties? Why not someone else who has a question about a hypothetical question?
My question might answer that. I can't remember, and you may not be able to either, but I'll ask. Did the counties make an allegation in this case that they were going to have to raise the rate of taxation in order to make up for the loss of valuation?
If you look at the petition, paragraph 17, it's very, very vague in that regard. And it talks about the words, this, it could be potentially this, it could this, maybe that.
That's what my recollection is. They didn't make an allegation that they were going to have to raise the rate of taxation.
No, I don't think so. And then also our argument would be, well, they'll get the same money. I mean, they'll get it from somebody else. And so if someone is actually affected by this, who is it? Who is really affected? And are they here? Or is this, as to these counties, is this a hypothetical question? Asking for an advisory opinion.
Well, that's why I asked the question about the directive where it says the county commissioners are the client of this appraisal process. Seems to me a client ought to be able to say that if these are the instructions being given for appraisal, that and we're the client, if they're unconstitutional, we've got a dog in the fight. Especially when they're going to have a bunch of other taxpayers that say, I don't want to bear this burden, extra burden that's created by this statute.
Well, that question too is there an extra burden or not? And so that question,
there has to be.
Well, the question is, yeah, is
and it's not a question of fact. It's absolutely an operation of law. You take the property valuation in a county, you know what the budget is, and you divide it up. And the folks that have a higher valuation have a higher tax burden than the ones who have a lower valuation. That's been the system forever.
But and that's the question, if it affects everyone, then who is the proper person to challenge it? And that's the question about this special nature of this writ. And if they had filed this as a declaratory judgment action in Shawnee County District Court, would we still be saying, no, you don't have standing? Well, possibly, but it would be a different standard that they would have to meet. But instead, they've come directly here with this original action, and it is a higher standard and a higher burden. And it should be.
So there's, just so I understand, by implication, there's no need for us to issue an opinion in this case by March 1. We can wait well beyond that.
Well, I think our opinion would be that you can dismiss the case. That would be one option.
I'm asking about the option I just presented. Can we just wait till, let's say, next fall to issue our opinion?
Of course, this court proceeds on its own time schedule, and that might be a question for the party seeking relief.
Well, she has waived her rebuttal time. You're the only lawyer I can ask that question of. So my question is there any urgency to release an opinion by March 1, or can we do it next fall?
Well, I think in the interim, the director and the secretary are going to follow the laws written. And that's the status quo, and that's what we're going to do. So, yes, if you delay, we will continue to follow the law as it currently exists. Now, whether that's going to cause practical issues down the road, I don't know, frankly.
All right, thank you. Any more questions?
Okay.
All right, thank you,
Thank you.
counsel. We thank all counsel for your arguments this morning and this afternoon. We'll take this matter under advisement. We turn